What if I told you that you might have a right to cancel a loan or debt within 72 hours with no questions asked? What if I told you that there is a little known rule that gives you the legal way out of financial obligations, but banks and lenders don't want you to know about it? In this video, we're going to be talking about the 72-hour rule for debt discharge, where it applies, and how you can use it to legally cancel debt contracts before they trap you. Now, just to tell you a little bit about myself, I've studied consumer law for since 2021, okay? Starting with credit, debt discharge, funding, and all aspects of consumer law. And my belief is that consumer law is one of the most important forms of law because you are a consumer. You consume, okay? If you consume, then you should understand and know how to protect yourself. Now, I'm going to be showing you guys the legal rights to use to protect yourself against bad debts agreements, which is probably 90% of the consumer credit contracts that you get into. Okay. Now, once again, thank you guys for watching this video. Like, comment, and subscribe. Okay. If you like, comment, and subscribe, then you and I can continue to invest in each other. Also, if you haven't checked out my last video, it will be clipped up here. Okay. So go ahead, check out my last video, then come to this video. I think that this video will really go hand in hand with my last video where I talked about being able to get a car for free. This is another strategy that you can add on top of that. And obviously, if you understand this aspect, then you could put yourself in an even better position when it comes to getting a free car. Okay. Now, also want to say, man, do not employ these strategies if you are not willing to do the digging and do the understanding. Okay. I'm giving you guys the game that nobody is talking about, okay? But I still want you to go and do your due diligence. Don't just go based off of everything that I'm teaching you right here. Do your own due diligence, okay? Now, if we're going to talk about the 72-hour rescission rule, we want to talk strictly about 15 U.S.C. 1635, the right of rescission as it pertains to certain transactions, okay? It says that, and we'll break this down in a second. It says that except as otherwise provided in this section, in the case of any consumer credit transaction in which a security interest, including any such interest arising by operation of law, is or will be retained or acquired in any property which is used as the principal dwelling of the person to whom the credit is extended, the obligor shall have the right to rescind the transaction until midnight of the third business days following the consummation of the transaction or the delivery of the information. Rescission forms required under this section, together with the statement pertaining to material disclosures required under this subchapter, whichever is later, by notifying the creditor in accordance with regulations of the Bureau of his intention to do so. The creditor shall clearly and conspicuously disclose, in accordance with regulations of the Bureau, to any obligor in a transaction in this section, rights of the obligor under this section. The creditor shall also provide, in accordance with the regulations of the Bureau, appropriate forms for the obligor to exercise his right to rescind any transaction subject to this transaction. Okay? It also says that when an obligor exercises his right to rescind under the subsection, he is not liable for any finance or other charges. You dig me? And any security interest given by the obligor, including any such interest arising by operation of law, becomes void upon rescission. Dig me? Within 20 days after the receipt of the notice, the creditor shall return to the obligor any money or property given as earnest interest, down payment, or otherwise, and shall take action necessary or appropriate to reflect the termination of any security interest created under the transaction. If the creditor has delivered any property to the obligor may retain possession of it. Dig me? Upon the performance of the creditor's obligations under this section, and the obligor shall tender the property to the creditor, except that if the return of the property in kind will be impracticable and inequitable, the obligor shall tender its reasonable value. Okay. Tender shall be made at the location of the property or at the residence of the obligor at the option of the obligor if the creditor does not take possession of the property within 20 days after ownership of the property vests in the obligor without obligation on his part to pay for it. Okay. I just read a mouthful, but I wanted to read this to you guys because a lot of what people we don't just say this out of our mouth. You dig me? We don't just say, oh, you can do these things just because like there's a theory. No, like Congress wrote this. You dig me? So long story short, the 72-hour rule, this is under the Truth in Lending Act, which is the truth in lending. You dig me? And it states that certain types of credit agreements can be canceled within 3 business days. Okay, so here's the key point. If you act within the 72-hour window, you may not be legally required to pay back the debt. Okay, now here's where it pertains to home equity loans and second mortgages, certain refinance loans, and some types of personal loans. Okay, now you also could argue that it doesn't apply to auto loans. You can also argue that it doesn't apply to credit card purchases. And you can also argue to most first-time home mortgages. Okay? Now, there are some theories out there where it essentially can work for any consumer credit transaction because technically the company doesn't have ownership over the debt. Dig me? Let's break that down right now. Okay? When you look at this, a lot of times the lenders will say, okay, well, the auto loan cannot apply under this subsection because, number one, right to rescind only applies to secured loans with a lien on your home. Okay, so essentially it says it applies to home equity loans, refinance the mortgages, and certain secured transactions involving a primary residence. Okay, and it also says that auto loans are not secured by a primary residence, so they do not qualify for this rescission right. This is something that they will do to challenge your right of rescission rights. Okay, so they'll say, okay, you can cancel a home equity loan within 72 hours, but you cannot cancel an auto loan under this rule. Okay. Also, they'll try to challenge and say car dealerships are one and done financing contracts. So essentially what happens is auto loans are finalized at the time of signing and immediately assigned to the lenders. Okay. Banks or the finance companies. It also says, unlike mortgage refinances, there is no cooling off period. Okay. And once you sign the contract and drive off the lot, you are legally bound to the loan agreement. Okay. You're about to get me in a sec. I'm about to get you in a second. So once you sign the deal is final. Okay. According to it being if it was an actual one and done financing contract. Okay. Unless the lender makes an error or engages in fraud. I hope y'all are following me here. About to debunk this. And it also says that car loans are considered purchase money transactions. So Truth in Lending Act rescission applies to certain types of credit transactions and not direct purchases. Okay. A purchase money loan, auto financing, is excluded from the 72-hour rule. What this means is that if you finance a car at a dealership, you cannot use the 72-hour rule to cancel it. Okay. It also says that car loan cancellations depend on dealer policies, not federal law. Okay. Some dealers offer a return policy. Okay. But this is not a federal requirement. And essentially, once the lender funds the loan, the contract is enforceable and the rescission is no longer an option. What this means is that the only way that you can cancel an auto loan is if the dealer failed to disclose material terms under the Truth in Lending Act. Okay. But can you still challenge the auto loan? Yes, you can. Okay. Even though we've talked about this in our previous video about the ways that you can challenge the auto loan properly. But here's the essence as to why everything that I just said is complete bullshit. You dig me? Because number one, based off of our previous discussions and what we have talked about and where loans come from, the fact that it's not a loan but our signature that created the credit, wouldn't this mean that the loan is not funded by the lenders, right? Wouldn't this mean that this is technically not even a valid agreement? Wouldn't this mean that this isn't even a one and done deal? Wouldn't this mean that this isn't a loan agreement? Wouldn't this mean that this isn't a financial, they haven't give you any type of money at all in the first place? That's exactly what it means. Because the question I'm asking is an auto loan a valid agreement if the lender didn't actually fund it? Absolutely not. Okay, because the lender did not provide actual consideration. You dig me? So in contract law, for a loan to be legally binding, it must meet the requirements of mutual consideration, meaning that both parties must exchange something of value. Dig me? And if a lender actually gave you money or actually never actually gave you money, but instead monetized your signature, then they did not provide real consideration. They didn't give you anything. They didn't exchange anything with you. Are you hearing me now? All right. So we understand that the banks don't lend their own money under the Federal Reserve information under modern money mechanics. When banks make loans, they create money, and the bank simply credits the borrower's account with a deposit of the size of the loan. This is in the modern money mechanics. The banks don't loan you pre-existing money. Okay, they created the credit using your signature as an asset, and since the lender never risked anything, they cannot claim that you owe them. They cannot say that you're under a legally binding contract where in the contract it says that they loaned you money. That is fraudulent. That is misrepresentation. You dig me? So if the loan lacks consideration, okay, given the fact that you signed a promissory note, which is a negotiable financial instrument under UCC 3-104, the bank converted your promissory note into credit and made money off of it without lending their own funds. So back to the fact that this is things that they're supposed to disclose to you under the Truth in Lending Act. So essentially, if the bank receives something of value and the banks did not provide anything in return, not being the money, and they gave you a vehicle, okay, that they paid pennies on a dollar for, there's no mutual exchange, so there's no valid contract. You dig me? And you have a right to rescind a contract that is not valid within 72 hours. And within that 72 hours, they have to prove that they have given you a valid contract. They have actually loaned you money, okay? So part of that, okay, this is when you tap in to challenging them on whether or not they're the holder in due course under UCC 3-305, which has the holder in due course rule, where you have a right to challenge whether or not they have sold or securitized your auto loan. And if they have, they have no legal standing to collect payments from you. Number two, if they cannot prove they own the original loan, they may be you will be able to challenge the debts. And also at the same time, when we talk about the Truth in Lending Act and the violations, failure to disclose the loaned funding under the Truth in Lending Act 15 U.S.C. 1601, lenders must disclose the full terms of the credit. So we pull that up under 15 U.S.C. 1601. The top thing says informed use of credit. Okay, so they must disclose any and everything about the credit, where the credit comes from, how you are using, how to use it, and they must avoid uninformed use of credit and to protect the consumer against inaccurate or unfair credit billing and credit card practicing. So again, if you essentially have gotten money from the loan and you're going to challenge and you're going to make me pay, again, that is considered fair credit billing, fair credit card practices. And this is all protected under the Truth in Lending Act. Okay? So if they fail to disclose these material facts, then a loan may be voidable under the Truth in Lending Act. Okay? So essentially, I wanted to debunk that because a lot of times they'll try to challenge you and say, oh, this is a one and done contract, or they'll try to challenge you and say, oh, well, you can't do this because it's not through the principal dwelling. okay, which also means the primary residence, which they're trying to refer to and say that it's only for real estate loans. That is just a game that they're trying to play with you, okay? And they try to make it seem like this is a different type of transaction than what a mortgage is, but it's the same exact type of transaction, because a mortgage, they sell your mortgage as mortgage-backed securities, and that's when it becomes securitized. That's when it becomes sold. That's when they monetize your signature. So not only did you guys fractionalize it, but then you sold my mortgage to an investor. Okay, so you made double money on my loan, and then now you guys are trying to come after me for the money as well. Okay, these are the things that you have to show to me and notify me of under the Truth in Lending Act. You have to give me the truth in your lending. Okay, so let's just get back on track on what you want to do properly to be able to challenge under the 72-hour rule when it comes to debt discharge. First things first, you want to use your right to rescind under the Truth in Lending Act, which is 15 U.S.C. 1635. If your loan qualifies, you have 3 business days, not calendar days, okay, to cancel it without penalty. Okay. Number 2, you must notify the lender in writing before the 72-hour period expires. So again, you want to rush this. As a matter of fact, you want to have that letter already prepared. You dig me? And you want to send it fast. Number 2, under UCC 3-501, which is the presentment of debt and conditional acceptance, essentially say that you can refuse debt within 72 hours if you properly condition your acceptance. So essentially, you would send a conditional acceptance letter stating that you require verification of loan funding and full consideration within 72 hours or the contract is null and void. So you have to give them an ultimatum. Hey, if you can prove to me that this was a real loan and you guys gave me full consideration or that you guys have full consideration, okay, that this is a legitimate agreement, then we can continue. But if not, this contract is null and void, okay? And here's the aspect of debt rejection under contract law. So if both parties haven't fully executed the contract, you also may be able to cancel within 72 hours. So if you never received full disclosures, you can argue that the contract is incomplete and unenforceable. So again, when we talk about any consumer credit transaction, they did not follow these steps here and cannot prove that they have full consideration, that they actually loaned you money, if they cannot prove that they have given all the full disclosures within that prior to you signing for that loan, then this loan is unenforceable. So when you give them an ultimatum and you say, hey, check me out, if you can provide the proof of this, then yes, we can keep it going. But if you cannot, this contract is null and void. Now it forces them to provide the disclosures. It forces them to prove these things within 72 hours. And if they cannot, then it is null and void. Okay? So now it forces them to perform. Now you have created a contract under UCC 3-501, which is now when you give them a presentment and you fall under the conditional acceptance, you're saying under no conditions, if you can prove this, then we can continue. But if not, then this is a fraudulent contract. And when they do not follow directions or they do not respond back, they have acquiesced to that. And when they acquiesce to that, you lose. Okay? This is not legal advice. Okay? All of this is broken down and complete that guide, the whole conditional acceptance process. Grab it down below. It's only $47. Now, how to use the 72-hour rule to cancel debt. Also, before I kind of move forward, if you haven't already, like the video. Okay? We at 14 minutes. I'm giving you guys 14 minutes of some untapped game that nobody is giving you out there. Also, leave a comment. Put the number 14. Let me know that you got this far. And because you're a real one. Okay? And also at the same time, man, subscribe if you haven't already. So the first thing you want to do is you want to send a rescission notice to the lender. Okay. If you don't know how to put that together, I have templates in the complete that guide on how to put that together. But if not, you can go online and find a PDF online. Okay. You then want to send it certified mail with a return receipt to ensure proof of delivery. Okay. Make sure you send it certified. Key language you want to use is say, pursuant to my right under 15 USC 1635, I am exercising my right to rescind this loan agreement effective immediately. You are required to return any payments made and release any claim against my credit file. Dig me? Revert that back if you need to. Write that down. Okay? Then after you do that, if the lender refuses to accept the rescission, demand full validation of the debt. Okay? This is when you dive into 15 U.S.C. 1692G, which is the Fair Debt Collection Practices Act section that talks about you challenging the validity of the debt and how you have a right to do these things. And if they cannot produce the original documentation showing full compliance with the disclosure laws, then the debts may not be enforceable. Okay? So again, you want to put them in a position where they cannot enforce this debt. You want to put them in a position when you're challenging them on the proof of the information that they said that they have. Okay, bet if you loan me money, then prove it to me. Prove that you loaned me money. Okay? Under this here, I know that you do not loan me money. So how about you just tell me where you got the money from? You tell me where you got the money from. You tell me that you got it from your own bank and you actually gave me cash in hand. Then yes. And I know you didn't give me cash in hand. I know that you just did deposits, which under 812 USC 1813, the definition of deposit is an unpaid balance. I know that under the Federal Reserve Act, Section 16, I know that in modern money mechanics that you don't actually loan money, but you create credit based off our signatures. I know that when it comes to a mortgage, right, you sell it as mortgage-backed securities, and it's not that you loan me money. You just type numbers or bookkeeping entries into my account, and then you release a security interest of a home to me, but you never ever gave me cash in hand. Okay? You only gave it to me because you was able to monetize my signature. Okay? You was able to sell my mortgage to an investor. Okay? That's the only reason you participated in this transaction, because you use me as proof of income. You use me as a way to be able to make more money. The only way you can participate in commerce is if I continue to sign signatures. You dig me? So when you start to challenge them on these things and they start to get to the space where they stop responding, or they do not want to respond, or they want to keep trying to send you letters and bills and things of that nature, listen, you don't have, I won't, it's not legal advice or financial advice, but if you do want to truly make this work, okay, this is when you have to start sending your challenges to the CFPB, sending your challenges to the Federal Trade Commission, and sending your challenges to the Attorney General's office, okay? Banks will rarely tell you about this rule, but if you act on this fast, you can be able to cancel certain debts before they become legally binding. Now, I'm putting this out there because this only will work if you will go through the full legal process. Meaning, if you take these steps and you say, boom, you understand these laws first, okay? Then you challenge them properly. You do the notice of rescission. If they refuse it, boom, then you want to challenge under the conditional acceptance. And you want to understand that, hey, boom, you guys refused it. Now it's discharge. So now we're going to go into the Fair Debt Collection Practices Act, and I want you guys to validate the debt in full. If they do not validate the debt, then they're already putting themselves in a bad position. Okay? And this is when you dive into, also when it comes to car loans, you want to challenge if they're the holder in due course. Okay? You want to challenge the fact that your promissory note was an actual exchange. You want to challenge that they given you the proper disclosures prior to the agreement. And these are things that you can use as this is what's going to go in the right rescission letter. Or if not, if you don't catch them in the right rescission letter, then you put it in the Fair Debt Collection Practices Act letter, which is the debt validation letter. Okay? Remember, you have a right to challenge any debt. You have a right to challenge any company on whether or not they've actually loaned you money. You have a right to do all of these things. They may try to make you think that you don't have these rights, or they may try to give you this, make it seem like this is a reverse trust scam, making you think that you can only move to the beat of their drum, or that they are in control. But all of that is bullshit. All of that is something that keeps us from actually taking action and empowering ourselves and letting us know that we actually have the power. That is the whole point. That's the whole system, to keep you distracted and keep you from actually trying to move forward in life because of these things that we are afraid to do, okay? And if it gets to a situation where you have to take them to court, build your evidence first by going through these processes and take them to court. you take them to court, if you need legal representation, do that. Tap in with legal aids in your state, okay? But other than that, thank you guys for watching this video. Like, comment, and subscribe. I appreciate you for watching this video. If you got all the way to the end, comment the word discharge, okay? If you want more knowledge, more information, check out the Complete That guide down below. It's only 47 bucks. I have all the templates, guides, over 200 gigabytes of data, and more importantly, I have my course instruction of me breaking down these laws and help you understand these laws even more. Number 2, if you want to work with me one-on-one, no, I don't particularly work on debt discharge. This is a more financial literacy focused mentorship, okay? So we're going to focus on credit. I can also teach you the aspects of consumer law and bring more clarity around my videos and things of that nature, but I'm going to be focused on getting the results, and that starts with your credit, okay? Because you can do these things, but then your credit might still get shot, and that is okay. It's not the end of the world if your credit gets messed up from doing these processes, because your credit getting messed up is not really that bad in the grand scheme of things if you know how to fix your credit, okay? So boom, fixing your credit, getting you funded so that you can be able to invest in your business. And if you don't know how to invest in business or how to get started, then I will help you get started in the online business space, okay? Number 3, if you need that legal help responding to a debt lawsuit, that is SoloSuit down below, where you can pay up front and they'll pretty much generate the letters, the debt validation process for you. And if you're in a situation where you're being sued by a debt collector and you need to take immediate action, you don't have time to learn, check out SoloSuit. And then lastly, check me out on Instagram, follow me there. I post daily content for motivation, financial literacy, debt discharge content, and more things in that nature, and also so that you can get updates. All right, again, drop a comment below if you've ever used the 72-hour rule to cancel the debt. What questions do you have? Let's talk about it. Also, if there's other things that you guys want me to talk about, drop it in the comment section down below. But don't forget to like, subscribe, and turn on the post notifications so that you don't miss my next video on debt discharge, credit, funding, and ultimately building to financial freedom. Thank you guys once again. I love you, and I'll see you in the next one.